Hello guys, this is Sanjana Parihar, intern at LEXIS and Company. I'm pursuing BA LLB and this is my first year. So today we'll talk about this very controversial topic, Love Jihad, which is actually known as UP anti-conversion law. Now this ordinance was passed by UP government, which deals with unlawful religious conversions, which is in opposition with various judgments of Supreme Court. Let's know about this conversion ordinance. UP Unlawful Religious Conversion Prohibition Ordinance 2020. This makes religious conversion for marriage a non-bailable offence, and this will be on defendant to prove that the conversion was not for just marriage. The notice period to the district magistrate for the religious conversion is 2 months. In case of conversion done by a woman for the sole purpose of marriage, then the marriage would be declared as null and void. Violation of the provisions of the law would invite a jail term of not less than 1 year, extendable to 5 years with a fine of 15,000. If a minor woman or a woman of scheduled caste and scheduled tribe converts, the jail term would be a minimum of 3 years and could be extended to 10 years with a fine of 50,000 rupees. Ordinance also lays down the strict action including cancellation of registration of social organization conducting mass conversions, which will invite a jail term to not less than 3 years, extendable to 10 years and with a fine of rupees 50,000 rupees. Supreme Court says about marriage and conversion that there's various judgments that held that faith, the state and the court has no jurisdiction over adults' absolute right to choose their life partners. India is a free and democratic country, and any interference by the state in an adult's right to love and marriage has a chilling effect on freedom. Intimacies of marriage lie into the core zone of privacy, which is inviolable, and the choice of the life partner, whether by marriage or outside it, is a part of individual's personhood and identity. The absolute right of an individual to choose a life partner is not in the least affected by matters of faith. Now there are some previous judgments. Hadia judgment 2017, where matters of dress and of food, of ideas and ideologies, of love and partnership are within the central aspects of identity. Neither the state nor the law can dictate a choice of partners or limit the free ability of every person to decide on these matters. Case Puttaswamy or Privacy Judgment with 2017. Autonomy of an individual was the ability to make decisions in vital manners or of concern to life. Lata Singh case 1994, Soni Gary case 2018, the Supreme Court warned judges for playing super guardians, succumbing to any kind of sentiments of the mother or egotism of the father. Salamat Ansari, Priyanka Kharwar case of Allahabad High Court 2020. The right to choose partner or live with a partner of choice was part of citizens' fundamental right to life and liberty, Article 21. It also held that earlier court rulings upholding the idea of religious conversions for marriage as unacceptable are not good in law. There are various problems with this laws that first of all is interfering with secularism, and despite this several states have had anti-conversion laws for a long time, including Orissa, Arunachal Pradesh, Gujarat, Himachal Pradesh and Jharkhand. against personal liberty. According to Article 25 to 28, an Indian citizen is guaranteed the freedom to practice any religion of his choice. Through this ordinance, the state wants to intervene not only in the citizens' personal liberty by interfering with the choice of their spouse, but also with the religion. Asymmetric with the various Supreme Court judgments, as we discussed. There's reverse burden of proof. We have also mentioned this earlier, that the burden of proof will be on the accused person. Patriarchal roots. This shows that the law has deep-seated patriarchal roots wherein women are infantilized, placed under parental and community control, and denied the right to take life decisions. Deep-rooted prejudice. This deep-rooted opposition of interfaith marriage is comparable to the similar deep-rooted opposition of intercaste marriage, in that both stem from historical prejudice between specific communities. In my conclusion, the government implementing such laws needs to ensure that these do not curb one's fundamental rights or hamper the national integration. Instead, these laws should need to strike a balance between freedom and malified conversions. This is all for today, and do let me know how did you like the video. Comment if there's any question related to this content. I'll get back to you as soon as possible. Also, this video does not solicit any kind of promotions or advertisements according to the Bar Council of India. This is for educational purpose only. Do let me know and like the video if you like the content.